Welcome to PodNumbra. The conversation starts now. Good afternoon and welcome to PodNumbra. I have a very special guest with me today, Mr. Dave Hendry. And Dave is a former counsel to the Collateral Regional Council, where he worked in death penalty appeals. Dave, welcome to the show and thanks for being here.
Thank you for having me. Thank you.
Absolutely. And Dave, just a little bit of a background of where we're going to be going today. First of all, I'd just like to learn a little bit about where you're from and where you grew up. So why don't you tell me about that?
Well, I'm born and raised in Tampa, Florida, and I think fifth or maybe sixth generation Floridian. My grandfather was Captain F.M. Hendry, Francis Merle Hendry, who started the Hendry Corporation. And then going back even further than that, my great-grandfather was Captain F.A. Hendry, Francis Asbury Hendry, who a lot of people have read the book A Land Remembered, and I think they're actually currently filming all around the state of Florida. They're doing a series of that at a movie, and so a lot of people might be familiar with the book A Land Remembered, and Francis Asbury Hendry was my great-grandfather. So the Hendrys are pretty firmly well established here in the state of Florida. There's a Hendry County in the southwest part of Lake Okeechobee. Clewiston and La Belle are the biggest, I guess, cities now, towns there in that county. So firmly established here in Tampa, Florida.
Yeah, and Captain Francis Asbury Hendry, as you mentioned, I believe he's one of the most influential Florida pioneers to his credit. And I think he is actually credited somewhere I read for establishing La Belle and maybe even Fort Myers. Is that right?
That's correct. I believe he had two daughters, Laura, and I'm forgetting the other one, but you put his two daughters' names together. That's how they got La Belle. That's the name of the city, La Belle. But it goes way back, and has a rich history. I think he was a senator, and he was also in the Seminole Indian Wars. So very rich history there.
So tell me, what does that mean for you being tied to so much Florida history when today's age, if you look around, there's not many people that are from Florida at all, much less have roots going back all the way to the pioneer days?
Yeah, I mean, a lot of people, they're surprised to hear that I'm actually born and raised in Florida. There's so many people coming down here from the Northeast, and I'm proud of my ancestry, proud of my history. It's been traced all the way back even to Scotland. It's interesting that we have the World Cup going on right now, and I saw that one of the defensemen there on the Scotland team was Jack Hendry. So he's like a 10th, 11th cousin or something like that, I'm sure. But I'm pretty proud of my heritage and proud to be a Hendry, and fortunate to come from this family, and so it was nice.
Yeah, so growing up in Tampa, where'd you go to high school?
I went to a Tampa preparatory school, and before that, actually went to, going even further back, I went to Seabourn Preschool on Davis Island. I think that's still there. And then kindergarten, I went to the Boys Academy. It was interesting back when I was in kindergarten, you had boys and girls together in the kindergarten class, and then you split, and I was there first grade through eighth grade. And so I was at the Boys Academy. The Girls Academy was across the street, and we used to go and look across the fence there, across MacDill Avenue, and say, oh, look at those. What are those? And it was interesting because my parents and grandmother, they wanted me to go to Jesuit high school because that was kind of the natural progression to go from the academy to the Jesuit high school. But I really wanted to get into class with those girls that I've been seeing across the street there. So that was a big draw to me for Tampa Prep, was that it was mixed classes, and also, like Jesuit, Tampa Prep had a really good reputation for academics, strong academics, and people graduating from Tampa Prep ended up going to some really good schools. And so Tampa Prep was my high school.
After you finished with Tampa Prep, where'd you go to college?
After Tampa Prep, I really wanted to get out of Tampa because I've been here 18 years, and I felt a strong draw to go to a big city, and I was looking at New York. So I only applied to NYU. That was the only school that I applied to. I was really gung-ho to get into that school and go there. So was able to do that. So it was 1988 that I went to New York University. And actually the first couple of years living there was pretty tough. That's New York. It's like a great place to visit, but do you want to live there? Maybe not so much. And so I was kind of burnt out of New York, and I was ready to leave New York, and actually applied to transfer to University of California at Santa Barbara. Always loved it out there out west, and got accepted to Santa Barbara. But my parents, who really weren't even really thrilled with me going to NYU, leaving the state. And they were like, well, you've kind of made your bed. Now you got to lie in it. So I was like, okay, so I guess I'll stay at NYU. And actually, that ended up being a great thing because my final 2 years at NYU were the best 2 years because I declared English major. And so part of my English major, I was able to take advantage of a lot of the arts in the cities. So I took some courses like drama and performance in New York City, where every week we would go and see like a play, a Broadway play or off Broadway, or go see an opera and then write about it. And that was included in the price of tuition. Also, there was painting and sculpture in New York City. So again, go to the Met and go and pick out a piece of art that you like there and then write about that piece. So it was a great kind of decision that was made for me to stay there at New York University because the class sizes got smaller and I could start to really pick and choose the courses that I wanted to take. And I kind of declared myself pre-law at that point. I had initially planned to go to the Stern Business School there at NYU. That was kind of the original plan, was okay, go to NYU and then after a couple of years transfer into the Stern Business School. But I don't know, after some tough economics courses and business calculus kind of did me in, I was like, okay, I'm done with this. And I decided that I'd like to read and write much more than crunch numbers. So it was after a tough business calculus class, I think, that I kind of switched tracks from the idea to go to business school because my father, I talked about my grandfather before. My father, Aaron Hendry, took over the family business with my uncle Harold. And they went from Hendry Corporation, which is over there around West Shore and Gandy. My dad sold that property, ended up going to the port of Tampa and started out Tampa Ship. It used to be American Shipbuilding Company. So I think George Steinbrenner had that company in the shipyard there, and they were building they had a big naval contract. They were building a giant ship for the Navy, but I think they fell on tough times and American ship went bankrupt, and my dad was able to buy them out of bankruptcy and start Tampa Ship. And he also had his Gulf Marine Company. So that's kind of the track that I was kind of intending to take, but I got diverted in New York. And so really switched tracks, decided that I wanted to go pre law and maybe be a criminal defense attorney.
Okay, cool. Just applying to NYU out of high school, you must have been a pretty good student to put all your eggs in one particular basket, especially that school, because I imagine the admissions rate is very, very low. And did you have any backup plans, or you just say it's NYU or I'm going to not go to college?
I think I did like the pre application. I think I was pretty focused pretty early on, maybe even in my junior year. I was deciding that I wanted to go to that school. And so I was very tenacious about it and put a lot of time, energy, and effort into. I mean, if I didn't get in there, I would have found option B or C or D. And people were persuading me to consider these options B, C, and D, other schools to go to. But I was able to get kind of like pre acceptance and able to get my kind of dream to go into a big city, New York, and get to NYU. And it's interesting that the turn that I took from thinking, okay, I'm going to go because Stern is a great business school, but things kind of changed, and I was happy with the change that I went with.
Yeah, and I'm right there with you. I only applied to one school out of high school, the University of Florida, which is the NYU of the South, as a lot of people call it. And I did not have a plan B or C, but I'm sure I would have developed one if I had to have one. What was it like living in New York City in the 80s? That was the height of the switchblade culture. You see all the movies where the street gangs and things like that. Tell me a little bit about what it felt like moving from Tampa being a small town even then to Big Apple.
Yeah, I mean, it's different. And in the 80s, New York in the late 80s, mid 80s, and late 80s were a lot different from the New York that we have now. And I was right in the thick of Washington Square Park. So my freshman year, I lived in Judson Hall, which was right on the south side of the park there. And it was crazy. I mean, Washington Square Park is a crazy place. There were street performers in there, and there was some guy in there. He was like a Harry Houdini and used to put himself in these locks and chains and contort his way out to get out of the locks and chains. And there were street performers. There was Tree Man. Tree Man used to put big roots on himself and branches, and he'd walk around. And there were drug dealers everywhere, like smoke sense, smoke sense. You couldn't walk through the park without being solicited like 100 times. And we used to have fun with it. Like we stopped, me and my friends, and say to the drug dealers, "Hey, you got squirrel knuckles, man?" They're like, "What are you talking about?" Because they're like smoked sense, you want to rock. So nobody'd be like, "Squirrel knuckle? What's a squirrel knuckle?" We're just kind of having fun with it.
Yeah, that was it also at the height of the, Nancy Reagan push to say no to drugs, and I'm sure you did. Let me ask you this, when you were at NYU, you said you wanted to do business, but then you had the change where you said, "I wanna be a lawyer, maybe a criminal defense lawyer." Where'd you end up going to law school?
I ended up going to Thomas Cooley up in Lansing, Michigan. So I took a couple years off, I guess, to just clear my head, and ended up filling my head up with LSAT equations. I hated that LSAT test. I think I took it like 3 times, and the third time I may have gotten the worst score of all three. I struggle with it, and so Cooley had a pretty liberal admissions policy, but the attrition rate, like, only like half the people or 40% of the people who got into Cooley ended up graduating. So I was nervous because of the LSAT. I struggled with that test so much. But when it came time to take the Florida bar, I was worried, like, oh, here we go. And then it was JFK Jr. What did they say? It took him 5 times to pass the New York bar. But I was really worried about the Florida bar, especially the Florida section, since I had been going to law school out of state. But I was able to, on the first try, I passed the Florida bar. So I was very happy with that.
So what year did you do that?
Went to Cooley 1995. So started in 1995, graduated in 1998. And interestingly, our hockey coach, John Cooper, he was there. I think he was a class ahead of me, or maybe 2 classes ahead of me. And I had a friend, Dennis from Boston, and he was like, "Hey, you got to meet our coach, Coop. You got to meet Coop." I'm like, "Okay." So they had like an intramural hockey team there at Cooley Law School, and Coop was the coach. And so it was really cool that I was able to meet him there. And he ended up obviously here in Tampa, and he lives just a couple blocks away here. So that's really cool.
Yeah, absolutely. So when you were in law school, you said you wanted to be a criminal defense attorney, and ultimately, when you graduated from law school, what'd you do next?
From law school, started with the public defender's office with Julie Holt. That would have been, I guess, late 1998 or 1999. So started at the public defender's office, and I worked in intake in the beginning. Like basically, I was in jail every day, and I was also on the microphone there at first presentation court. And it's the public defender's office is like trial by fire. I think I've always been interested in law. I've been interested in court cases, and even going back to the mid to late 80s, like on my spring break and summer breaks, if there was a big trial going on here in the city of Tampa, I wanted to go watch that trial. So when I went to law school, the OJ case was going on. So I watched a good 80 to 90% of that case going on. And I was a big fan of Johnny Cochran and his closing argument. Like, you're going to hear the prosecutor talk about, don't blame the messenger, don't blame the messenger. Well, who brings you that message? Who brought him that message? Mark Furman, the man who found the glove, and Philip Van Adder, the man who found the blood. The twins of deception will bring you a message you cannot trust. If the glove does not fit, you must acquit.
That was great. I remember watching the, verdict of that trial. I think I was
Um,
in 10th grade, and they wheeled in a television into my high school classroom on one of those media center televisions that's on a cart that's on wheels that has an extension cord, and we watched the verdict read. I mean, that was a formative time, and obviously, there's a question of whether or not that, trial was rightly decided or not. I don't know. I wasn't there. Didn't watch as much as you did, but, it's definitely a big part of our lives, at that time. So other than working for the public defender's office, and I've heard a lot of this, like you get in there, you're essentially drinking through a fire hose. You have all these cases and you're just basically trying to keep your head above water. Did you start in misdemeanor or felony, or which division were you in?
at the public defender's office and started an intake. So when people are first arrested, they go before a judge typically within 24 hours to be notified of the charges that are against them. And the judge will then set the bond or put them on no bond hold. So I worked there for, I don't know, it's hard to remember, several months. And then from there, I went to the juvenile division, which was really cool. I was there for a while, and I actually tried, I think it was about 80 to 90 adjudicatory hearings. So these are like bench trials, because the juveniles don't get a jury trial, but you practice before a judge, and the judge will hear the evidence and make the decision of guilty or not guilty. So had a great time in the juvenile division, was able to try so many cases, and from there I went to misdemeanor and was able to try some DUI cases and some other types of low level crimes. Then I worked a while after misdemeanor. They put me in a drug court. which was cool. And I was with Judge Don Evans in drug court. And that was an interesting time because Judge Evans was very interested in seeing people who were addicted to drugs get drug treatment. And that's why he kind of like established that drug court, was to ensure that instead of people just getting long prison sentences for drug offenses, he would ensure that they get drug treatment, they go to different drug treatment programs and such. I was kind of a thorn in his side a bit, because my interest was in seeing that if someone's constitutional rights were violated, if I saw like a motion that had to be filed, I'd be filing the motion. Or if I saw that there were some, questions of guilt or innocence, I would be wanting to try the case. So I filed a lot of motions in that division, and I took a lot of cases to trial too. And Judge Evans was like, what are you doing, Mr. Hendry? What are you doing? You're like, these people need some drug treatment. And I'm like, well, Your Honor, these people, they need to have their constitutional rights respected. And if they're violated, if I see a motion, I'm going to file the motion. If I see these issues in the case. So it was an interesting time in there. And then I remember one time he's like, well, he felt like he was spending too much time trying cases with me. So he would send some of the cases out to the trial division. I remember Judge Barbara Fleischer was there in the trial division. And I think it was a possession of cocaine case, but it was just a crack pipe. And so the question was like, why is this person being charged with felony possession of cocaine when it's just a pipe with just simply residue? And that should be a misdemeanor, not a felony. And I remember Judge Fleischer kind of understanding the case and understanding where we were going with this. And, she'd put her glasses down on her nose and looked at the prosecutor and she said, this is a residue, this is a pipe, this is paraphernalia. Where are we going with this? And I think she might even, I don't know, she kind of twisted the state's arm to offer a reasonable offer. He'll plead to possession of paraphernalia rather than get the felony charge for possession of cocaine. And I remember it happened very quickly. And then so I go back up to see Judge Evans. He's like, Mr. Hendry, what are you doing here? We're done, Your Honor. What do you mean you're done? I thought you were trying the case. I'm like, well, it was just a pipe, Your Honor. So, okay. So then we carry on to the next case. But it was a great trial by fire. It was, got so much experience there at the public defender's office. And like I said, 80 to 90 adjudicatory hearings in juvenile. And I tried several misdemeanor cases and tried a lot of cases there in drug court. And I think on one day I actually argued like 5 motions to suppress or 5 motions to dismiss. So it was a busy, busy time. But I started to hear about Capital Collateral Regional Counsel and about how you don't have this huge caseload and about how you can really dig into these cases. The caseload is more of like 12 cases to 16 cases or something. And reading and writing was always kind of like my bedrock. So, and that's why I kind of switched from the idea of business school to going to an English literature major. So I did make the switch from the public defender's office to Capital Collateral Regional Counsel. I did that in 2002. And it was an experience. I ended up working there for 20 years.
And just so everybody knows, tell me what exactly is Capital Collateral Regional Counsel?
It's part of the state of Florida. So we have a public defender's office in the state of Florida. So the state pays for both the defense and for the prosecution. The state funds the prosecution office. They fund the public defender's office. So I shorten it to CCRC. Again, the state will fund the Attorney General's office and they fund the Office of Capital Collateral Regional Counsel. So my adversaries at CCRC were the Attorney General's office and also locally the prosecutor's office where the murder occurred. So the state funded both the prosecution, they funded the Attorney General's office, they also funded there's actually 3 offices of CCRC. They have one in Tallahassee called the North Office. And of course, here in the middle region, it's Temple Terrace actually. And then they have another office down in Fort Lauderdale at CCRC South.
So your clients at the CCRC, those are individuals who had been sentenced to death by the state, and you come in as their attorney. The defense is paid for by the state. You are trying to, one, attack the underlying guilt verdict and also the sentencing verdict. Is that right?
That's correct. I was telling you, I started back in 2002. And in the first week, I think it was like, welcome to CCRC, Dave. And here's your first case. It was a DNA case, and the rule was very fresh on DNA testing. So 3852, I think, is the Florida Rule of Criminal Procedure that was at issue. So, you had a right to take this biological material, many cases like very old material. So the first case that I worked was Paul Hildwin, and I believe that's a 1985 case that originated out of Hernando County. And so the lead attorney and the investigators are handing, here's your Paul Hildman case. And what's the bottom line here? They said, well, we have exculpatory DNA evidence. So what was interesting in this case is they had already filed motions to get the material and have it tested. The material had already been tested by the laboratory, and the results were in, and the results were exculpatory. And this is DNA evidence that did not belong to Paul Hildwin. So I'm like, what's the issue? It's like, I was really puzzled. Like, why, it's supposed to be that when the DNA evidence doesn't match the defendant in post conviction, he's released from prison. There's a ticker tape parade. This is an innocent man. He's been locked up for decades. And it's really a good thing that we didn't execute this man. Well, in this case, it was, I was very puzzled because he was still on death row. He was still locked up, and there was real pushback from the other side, from the Attorney General's office and from the Hernando County Prosecutor's office. They were saying the DNA evidence is irrelevant. I was like, well, wait a minute. I started to dig into the case. I'm like, back at trial, back in the late 80s, the prosecution had called these FBI agents from Quantico, Virginia, to basically testify that Paul Hildon's biological fluids were left behind at the crime scene. They said he was a non-secretor, and a non-secretor only makes up 10% of the male population. But they were basically saying to this jury, they wowed this jury from Hernando County to say this is like pre-DNA. And they're saying like the biological fluids left behind in this car where the victim's body was recovered belong to Paul Hildwin. He's a non-secretor. This is his blood. This is his saliva and semen, and therefore, because it matches him, he's likely to be guilty of first-degree murder. So, again, I'm like, well, now we know that was absolutely 100% incorrect. It's almost like this was bad junk science that was used back in the late 80s by the prosecutions to obtain a conviction and a death sentence against Paul Hildwin. So it was a real battle. It was a real fight, and a very long story. I don't know if I should get into it some more, but
Feel free. Yeah, no, first of all, before you do, what is a non-secretor? I've never heard that term before.
okay, the state was saying, and their experts were saying, that non-secretors only make up 10% of the male population. So this was the state's theory. This is how they were trying to turn the evidence to make it very inculpatory against Paul Hildwin. So they said only 10% of the male population are non-secretors, meaning they do not secrete their blood into their bodily fluids. So the experts that testified at trial said, like, yeah, we can tell you, ladies and gentlemen of the jury, that the semen and the saliva doesn't contain his blood type or something like that. We weren't able to obtain a blood type. So we know, therefore, and we tested Paul Hildwin, and we know that he's a non-secretor male. That's a very rarity because 90% of the male population are secretors. So he's part of that rare 10% of non-secretor. So they said that makes him much more likely this is his biological fluid. But it's like, well, the DNA evidence says 100% it's not his biological fluid, And that's when we had the fight. They were trying to say that the DNA evidence was not relevant. And it's like, well, wait a minute. How can you, use this junk science, this biological evidence against him in the late 80s to convict him and put a death sentence on him, yet not concede that there is certainly some relevance to the fact of it's not his biological fluid left behind there at the crime scene.
What other evidence did they have? Did they have something like an eyeball witness placing him at the crime scene? Or, they must have had something else other than this non-secretor,
Yeah.
theory.
The way it panned out is that he testified at trial, and he said he was hitchhiking, and he said this couple picked him up, and it was a man and a woman, and the man started beating up the woman and turned into like a domestic situation there in the car. Now, Paul Hildman, no angel, took her checkbook, I think, out of the purse that was in the back seat. And that was his testimony. So at trial, the defense, his position was that, I didn't rape and murder this woman. I simply was getting a ride, and then it got abusive there in the front seat. And I took the checkbook and I left, and he ended up cashing the check on her account. So certainly that's very inculpatory evidence, but that's only inculpatory evidence of, check fraud, forgery. So there was some evidence against him, but it was a very circumstantial case. And I was up against in post conviction a standard called the Jones standard. And you have to show under the Jones standard that there would be a probability, a likelihood of a different result at trial in light of the newly discovered evidence. So our newly discovered evidence was the DNA evidence. And so I had to show, well, I'm like, how am I going to show the courts that if he presents this evidence that he's going to be acquitted? And I actually used the services of Harvey Moore. Dr. Harvey Moore was a longtime professor at University of South Florida, and he was a jury trial consultant and a jury trial expert, and he did a lot of trial simulations. So in like very high stakes cases, he was hired by these lawyers to make sure that the right jury is picked, the right people are stricken from the jury, and who to stay away from on the jury. But we ran trial simulations, and we presented kind of the evidence that was presented at trial, and then we inserted the newly discovered DNA evidence. And in these trial simulations that were conducted, it was a really cool process. Like he had an office in downtown Tampa and the Bank of America building, and he actually bussed in, I think, 36 people who were willing participants in these, I call it a mock jury trial or trial simulation. But, I was trying to present that evidence to the post-conviction court to say we certainly meet the Jones standard here, because we're not just arguing that there's a probability of different results and different outcome at trial, but these juries and these mock trials actually voted not guilty in light of the newly discovered evidence. Now that evidence was basically largely discarded by it was Judge Tom Brink out of Hernando County. We appealed to the Florida Supreme Court. It was one of my first arguments at the Florida Supreme Court, and we were primarily challenging the conviction to say, like, you can't convict this man if there's exculpatory DNA evidence. And so Judge Tom Brink had ruled against us. We were appealing to the Florida Supreme Court, and if you don't want to vacate the conviction, we were saying, well, you certainly shouldn't execute a man. Sure seems to be innocent, or real questions linger there about his guilt. And I remember after arguing that case, I got a call like 3-4 months later from the Florida Supreme Court clerk, and they said there's a decision in the Paul Hildren case. And all of a sudden, my heart's beating really fast, and I'm thinking, because I thought we won. Because there was a case pending at the U.S. Supreme Court, House versus Bell, which was decided favorably during the pendency of my appeal on Hildren. And I remember the clerk said to me, affirmed. And I was like, affirmed. And I was thinking about that. I was like, so he didn't win? And she's like, no, affirmed. And I'm like, death sentence too? Like conviction and death sentence? Yeah, everything's affirmed. And it was just like, whew, man, it was like my guts just hit the floor of my office. It was like, are you kidding me? Like, ugh. And it was it was a tough decision. It was 3-4, so 3 judges felt like he should get a brand new trial based on the newly discovered evidence. 4 judges ruled against us. So, it's a tough job. And you talk about trial by fire in the public defender's office. This was like trial by fire at Capital Collateral Regional Counsel, because, it's a case that I did not expect to lose. And I lost at the circuit level, and we lost 3-4 at the Florida Supreme Court. And it was just kind of devastating, and to have that conversation with your client and break the bad news. This is a very tough job.
Yeah, absolutely. And when you were saying that, I'm imagining when a surgeon comes out of the operating room and he has to break the news to the family waiting in the room. It's like, we weren't able to save your family member on the operating table. That's kind of the news you have to deliver in that sense, because once it goes up to the Florida Supreme Court, I guess you could potentially file something to the U.S. Supreme Court. Is there another level of review after that, or is that the end of the line? And even if you are, is that essentially a Hail Mary that you're throwing to try to save this guy's life?
I think as you proceed further and further in the appellate system, it gets more difficult because the federal system is governed by the EDPA standard, which is you got to prove in the federal courts that not just a wrong decision was made in the state courts, but that it was an unreasonable decision. So you've got the deck really stacked against you. You want to certainly try to win these cases in state court, because federal court's not getting any easier for you. The standards just get more difficult and more difficult. But, Hildren was interesting because we had this DNA profile and we knew it didn't belong to Paul Hildren. And what we wanted to do, and I was working with the Innocence Project, I was working with Barry Scheck and Nina Morrison, who did the oral argument with me at the Florida Supreme Court. We wanted this sample to be placed in the CODIS system, which is the system which is going to identify who the DNA belongs to. But the strange thing is, Florida Department of Law Enforcement and the AG's office and the prosecutor's office were fighting this, and they were saying, "We're not going to put this evidence in the CODIS system because it's got to belong to the putative perpetrator." And we're like, "Yeah," and they're like, "Well, the putative perpetrator is Paul Hildren, not anyone else." And we're like, "Well, we disagree." And we're like, "Just put it in there, you know." And for years and years, this fight dragged on. Paul Hildren was just trying to get the piece of evidence entered into the CODIS system. And sure enough, it got entered and it came up on the alternate suspect. His name was so not only was it not Paul Hildren's DNA, but it belonged to the alternative suspect who lived with this victim in Hernando County. So then kind of they call it a successive appeal. So it's like now we're coming back to the Florida Supreme Court and we say, "Hey, Florida Supreme Court, we've got the DNA evidence. It belongs to the alternative suspect. So now we really meet the Jones standard because we know whose DNA it belongs to is the alternative suspect." And he ended up winning that appeal. I had kind of moved on to other cases, and the attorney who had the case at that point was Marty McLean. He had a ton of post-conviction cases. He was a very big post-conviction attorney in the state of Florida. So the Florida Supreme Court ruled in his favor based on it not being Paul Hildren's DNA and it being belonging to the alternate suspect. Now, I think there were even two dissents in that case. So even in light of that, I believe the decision was 5-2. But you had two justices from the Florida Supreme Court who still felt that Paul Hildren should not have received a new trial based on this evidence. But the state continued to fight it because they still said he's guilty and we're not conceding that he's an innocent man. And it dragged on for years and years more. And the state was going to retry him. And Leanne Gowdy took the case. She was going to try the case. She's now a judge here in Hillsborough County. And she was working the case pro bono. And she was getting ready to try the case. And then I think Paul Hildren got cancer and they had to continue the case for a couple years. Finally, it was in 2020, I think early 2020, they finally gave him an offer he couldn't refuse. He accepted to plead to a lesser and accept time served. Ironically, like right when he got off death row, out of prison, COVID, and now he's a prisoner in his own home. We were on lockdown, so. But I guess it's much better to be locked down in an apartment than on Florida's death row or Hernando County jails.
Yeah, so that was your first case that you got assigned in 2002, and then
Mhm.
it continued on for 18 more years all the way up into COVID?
That is a situation. We've got exculpatory DNA evidence. It does not belong to Paul Hilton. We know this in 2002, and it is not until January, February 2020 that he has his freedom.
And I think people are always a little bit confused and baffled about the death penalty process because it takes so long. You'll hear a snippet on the news that so and so from 1988 murder of these two hitchhikers was finally put to death in 2024. And as a passive observer, you're like, well, what took so long? But with that explanation, I think that provides people that are on the outside looking in a lot of explanation as to what took so long. And really, the issue is we're fighting over the life of a person that the state is essentially trying to put to death. And right or wrong, the government certainly makes errors. There's certainly political motivations that are involved in these decisions. Obviously, you're talking about the attorney general and different people at that level. Those are all people that run for office. And tough on crime is often a plank in their platform when they're running for office. And the Paul Hillwins of the world, if they're just under their watch, if these guys are just getting turned loose out of the jail, that may be a liability for their political election. Not saying that any politics played specific into this role, but certainly I assume that's something that you ran across in your career defending condemned criminals.
Yeah, absolutely. I mean, a lot of people want to be tough on crime, but I think in this case, you're a little too tough on crime. I just felt like all throughout the process, the people making these high level decisions were just being way too stubborn and turning a blind eye to, of all things, DNA evidence, because I think that was my only DNA evidence case. So I worked there at CCRC for 20 years. I left in March of 2022. But in that 20-year span, that was the only case where I had exculpatory DNA evidence. Like, that doesn't happen very often in post conviction. That would have to be the gold standard of trying to find evidence to present to a court to persuade them to vacate the conviction and vacate the death sentence.
Yeah, it's kind of the opposite of having from the prosecutor side, they have the smoking gun piece of evidence. You have the opposite. You have the non-smoking gun piece of evidence, which is going to basically open up the prison doors and let your guy go free as long as you can get that evidence in front of the right person and then they can make the right decision. What about this? Like in an alternative role, obviously you're trying to get this particular client off death row, get his sentence reduced, whatever the situation is. Then there's an alternative defendant who the evidence pointed to him with the DNA evidence. Let's say Mr. Hildwin, they release him, they go pick up this other guy, he gets tried, put on death row, and then ultimately his file falls on your desk. You're like, oh, I remember you. It's like, well, look who's here. How would you approach something like that?
It kind of just boils down to the Fifth Amendment and due process of law. So the state cannot take away one's life, liberty, or property without the due process of law. And so many times, what I'm saying, I can't tell you 100%. I don't have a crystal ball here to say Paul Hildwin is innocent. It's almost impossible to prove one's innocence. But what we have proven absolutely 100% to the court is that there was a lack of due process, because when you're resting a conviction on junk science, bad science, the secretor stuff, that's not due process of law. We know 100% that he did not receive a fair trial. So, if you talk about, I probably might have a conflict of interest. I can't represent him. I don't know. That file's probably gonna leave my desk and go to someone else's desk. Might go to the North region or the South region. But post conviction is interesting, and it's very, very difficult. And Paul Hildwin, this case just always sticks in the forefront of my mind. A lot of times we're dealing with just the death sentence itself, not the conviction. But a lot of times we are trying to challenge the conviction as well. And one of my other strongest cases that I had there at CCRC was a guy's name is David Francis. And one thing that we discovered in the David Francis case is that there was an African American juror who was wrongfully stricken from the jury. The case out of the United States Supreme Court is called Batson. So when there's a process to ensure that minority jurors are not wrongfully stricken, and in David Francis's case, we know 100% absolutely that there was an African American juror struck from that panel based on her alleged opposition to the death penalty. She never once announced that she was opposed to the death penalty. That case was out of Orange County, and that was a case that I thought I was going to win for sure, and I didn't win that. But my success rate, I was probably once every 4 years, I would get like a significant victory, and mainly that came in the form of they would vacate the death sentence, not just because you don't, to try to get a conviction vacated is like moving a mountain. Really, really difficult.
Yeah, so to be clear, it's not your role to necessarily I mean, of course, if you can determine the innocence of your client, that's one thing, factually innocent, but as far as procedurally innocent, that's more where your role is focused, right? Because it's the state's job to carry the burden and prove their case and to put this person behind bars or to death. That's up to them. And if they can't carry the burden because they haven't provided the correct process to the defendant, and that includes all the things you've discussed, you can after the fact, and certainly during the trial initially, but sometimes that doesn't get done because of a variety of circumstances, ineffective assistance of counsel or whatever, ultimately, or just that the case is being tried in small town Hernando County or small town Liberty County or wherever it's being tried. Justice is a little bit different county to county, state by state, as history has taught us. So you come in after the fact and you're essentially looking at the facts of the case on appeal. You're looking at the appellate record and you're trying to identify was process provided to this person. In the Hildwin case, specifically about the DNA evidence that was exculpatory that was not allowed. That's a giant red flag. And of course, like you said, you always don't have that giant red flag, but you're still looking for issues to make sure that the defendant, your client, got all the process that he or she was due.
Right. The one analogy that I've used over the years is that, what is post conviction? What are we doing here in post conviction? And it's kind of like the analogy of the Twin Towers have been knocked down. So the planes have already hit the building, and you just have a pile of rubble. And as a post conviction attorney, you're kind of digging through this rubble to find signs of life. When I say signs of life, are there, some viable appellate issues that we can proceed on? And with the Hildman case, that exculpatory DNA evidence, it's like, wow, like, they're alive, they're alive. This issue is alive. This case is alive. Now, a lot of times there's nothing, there's no signs of life at all. It's just, you're coming in at a very tough time in post conviction because the person has already been convicted. The person has already been sentenced to death. And that person has already had their direct appeal to the Florida Supreme Court. So when we come in, it's a lot of like legal destruction that has already happened. And a lot of times there's very few issues and sometimes some very weak issues in the case. But we were always trying to find what we could. We were seeking high and low and working with our investigators and doing the best we could to try to find some things to challenge the conviction of the death sentence.
Was it difficult balancing the work that you did representing condemned criminals in conjunction with potentially representing somebody who, the facts of the case or the circumstances, they may be, somewhat viewed as an irredeemable person in the sense that, like you said, they may have done what they're accused of, but ultimately maybe they didn't deserve the death penalty. Maybe they deserve life in prison or something like that, but they still did a heinous crime. How'd you balance that in your own mind?
This goes back to one of the offices that I interviewed with when I knew I wanted to work as a public defender early in my career. I was at the Pinellas Public Defender's Office, and the question came up in my interview, how can you represent someone who's basically like a monster? Like, do you have any problems with legally representing this really, arguably viable creature, a monster. So, the public defender analogized it to you shouldn't have a problem with that as a lawyer because let's say that you were a doctor. You're not a lawyer, but let's say that you're a doctor and it's the emergency room. And this person arguably has done some very horrible things, like unspeakable things. But as a doctor, you're going to say, like, I don't know, you can't let him go. I mean, the doctor swore an oath to try to preserve people's lives, and he's not going to do any less of a job because it's a serial murder or something there on the operating table. So I looked at this from that standpoint of I'm not here to judge my client. I'm here to try to find any evidence whatsoever that I could find to try to challenge a potentially unconstitutional conviction and death sentence. So, I mean, sometimes it was scary. Like, I had one client who was like threatening to kill me and my co-counsel, and we were sitting there, and his issue was that he didn't want any of our help. Like, he was like, don't you dare try to get in between me and the gurney. He was kind of like call it suicide by the state kind of guy. He was always trying to get the cops to shoot him and kill him. And so there he wanted to be executed. And he wrote many, many letters to Jeb Bush, calling him names, calling him
To pull the lever.
yeah. Hey, Governor Bush, you don't have the courage to execute me or whatever. And that was the quickest execution ever because like no person has gone so quickly from date of murder to execution as quick as this guy. Glenn O'Shea, I think was his name. But yeah, he really wanted to be executed. And he saw me and my co-counsel, we went to visit him there in jail as a threat to him being executed. And he was like, I've killed people before. I'll kill you.
In that circumstance, with that particular individual or any individual in his circumstance on death row, is he allowed to waive his appellate rights? And he sees someone like you come in and knock on his bars of his jail cell. And he's like, you know what? I don't need your help. I'm ready to go. Let's fast track this thing. Is that an election that they could do?
Yeah, they can elect to waive their post conviction appeals, and so like in that case, we said that's fine. We just got to go through a process. The court's going to appoint a couple of mental health experts and make a determination about whether you're competent to make this decision to waive your appeals. And so they do have the right to waive their appeals, but it's just the court would have to appoint a couple of mental health experts to make that determination.
Yeah, that's interesting. Do you think, in your opinion, is the death penalty administered fairly?
I don't think so. Going back to the Paul Hildeman case and just my personal opinion is that it's just too much power. Like I just feel there's an abuse of power there or the potential to abuse power. So there was a justice, I believe it was Justice Blackmun, and I believe he said one time in the late 80s that I shall no longer tinker with the machinery of death. So you had a U.S. Supreme Court justice who said, when it comes to death penalty cases, I'm out because he felt like the death penalty could not be carried out fairly or constitutionally. So I'm against the death penalty, and I think that helped me in my job working there for 20 years straight, 2002 to 2022. It helped me to have that opinion that I feel like there's an abuse of power or just the potential to abuse power. And I think a lot of times, unfortunately, it's done for political reasons. And we're seeing this year and last year, we're seeing a tick in the number of executions here in the state of Florida. And it's kind of happening quietly, but we're reaching like 24 to 36 executions per year this year and last year. But, the death penalty is, I see it, it's looked upon with disfavor more and more as time goes on. They talk about the evolving standards of decency that mark the progress of a civilized nation. But, they don't have the death penalty in any European nation. There's a lot of states in the United States of America who have done away with the death penalty. Some very pro death penalty states, like Virginia, was one. There were a lot of executions in the Commonwealth of Virginia, and they abolished the death penalty. And, here in Florida, it's executions are occurring at a very alarming rate. I think, just yesterday, they executed oldest inmate. I think he was 74 years old and he was a veteran. He was a former Marine. So it's a hard no. That's my short answer.
Yeah, when I was in law school, I remember in my constitutional law class, I remember reading about a case. I think it was about cruel and unusual punishment, and there was a condemned criminal in Louisiana who was being put to death, and he was challenging the death penalty because I think he was excessively obese, and they were saying whatever they're going to do. I don't remember how they were going to put him to death, whether it be hanging or lethal injection or whatever. But he was saying that was cruel and unusual punishment. And I remember my law professor, my con law teacher, saying, if you get to the exam and you're uncertain whether or not a law is unconstitutional or not, for the purpose of the exam, if the law was passed in the state of Louisiana, you could err on the side of unconstitutional almost every time. And I just remember laughing about that and keeping that in the back of my mind when I was taking that con law exam, which I did very well on.
So you mentioned a very obese man because I think his nickname was Tiny Davis, but he was like, 400, 500 pounds or something like that. But this goes back to the late 1990s in Florida. And this was a very obese man. And there was a question, and this is when we had the electric chair, Sparky, and it was botched. It was horribly botched. And witnesses were talking about his head was catching on fire and it just wasn't going as planned. And just, horrible. I think that was the last execution we had by electric chair here in the state of Florida. And I came into CCRC right on the heels of that. So the new method of execution was lethal injection, but it was that Davis execution in the late 1990s that did not go well. And said, he was a very large man. And that's probably why it didn't go
Yeah,
as
and
it
we
should.
talked earlier about having a plan B for when they're putting someone to death like that, like with the electric chair. Is there a plan B on deck in case it doesn't go well, or like is there a plan? Or they just assume like this will work. We just have to give him more juice, so to speak. Not to be morbid, but you certainly think that electricity would be sufficient to put a man to death, but I guess not all the time. Or did he ultimately die?
Yeah, it just was in grotesque situation. It was bad, not something that anyone would want to have to witness. He was executed, but it was obviously a very, very bad situation. Not something that anyone wants to happen, especially even proponents of the death penalty, something like that. But it's interesting, like, I think there was just a decision out of the 11th Circuit Court of Appeal, out of the court in Atlanta, that said that what the state of Alabama was doing and their lethal injection procedures, I think, was unconstitutional. And the threat of, cruel and unusual punishment, that's the issue, the Eighth Amendment, like these methods of execution. And so it's like, what are you going to use? In Utah, they use the firing squad a lot and lethal injection. A lot of people are using that, but electric chair is kind of out. They're not using that a whole lot. But going back to Justice Harry Blackmun, it's like he just was not into tinkering with this machinery of death, and he was out.
Yeah, and then I've heard about Utah, their utilization of a firing squad, and I always wonder if that is that a procedural or strategic decision by maybe the defense counsel at the sentencing phase where to say, you know what, I'm going to select firing squad and kind of throw the judge or jury for a little bit of a loop because a lot of people are used to the lethal injection and they're like, wait a second, firing squad, I don't know if I'm okay with that. And maybe, if somebody was in favor of the death penalty by other means, maybe now it's a firing squad or, I don't know if you get to choose like Shark Tank or electric eels or whatever, something to where it's going to give that person who's voting for that type of death, give them pause and say, you know what, you don't get my vote because I'm not in favor of the guillotine or whatever.
I'm sorry, what was the question?
No, I just wonder if a strategy that's employed at the trial level when in the sentencing phase, whether say, if your selection, if you're choosing, if you could have a choice choice between lethal injection or firing squad is a little bit out of the box in the sense that I know it's been used historically militarily and it's been around and it's pretty effective. I think 100% effective, actually, if you drill down on the numbers. But is that used as a strategy to try to flip a vote that otherwise might vote for a more traditional way to affect the death penalty as opposed to something you don't see every day? I don't know. That's just a thought I've had.
Yeah, I mean, I had a client one time who said that he wanted to be hauled up in a helicopter top of volcano, and he wanted to do like a quadruple gainer into the volcano. He said that's the way he would want to go, and he said he wanted it to be on like pay-per-view, TV, heavily televised. And I don't know if the guy was serious or if he was like joking or just trying to be, shocking or whatever. But he's like, yeah, it'd be great. I'd be up there on the platform there, that helicopter over that volcano, do my quadruple gainer.
Was he a diver to begin with, or we'd have to learn how to do a quadruple gainer in order to affect this final outcome?
I don't know.
In addition to my request, I'm also gonna need 3 to 4 diving lessons before we do this. That's gonna be denied, sir. No diving lessons. And that leads me into my next question, which is the concept of the ritual of the last meal that you always hear about the condemned criminals getting, and I think there's some historical ones where I think Ted Bundy essentially declined a last meal, and he received the standard prison meal, which was steak, eggs, hash browns, toast, milk, coffee, juice, butter, and jelly. I looked this up before we were talking, and what caught me about that one, not only did he decline the meal, but there was a lot of beverages involved with that meal. That he's getting coffee, juice, and milk. Lawrence Russell Brewer, a gentleman that was executed in Texas in 2011, requested 2 chicken fried steaks, a triple bacon cheeseburger, fried okra, barbecue, pizza, 3 fajitas, a pint of ice cream, peanut butter, fudge, and 3 root beers, but then reportedly did not eat any of it. Timothy McVeigh of the Oklahoma bombing, he chose 2 pints of mint chocolate chip ice cream. John Wayne Gacy requested a dozen fried shrimp, a bucket of fried chicken, French fries, and fresh strawberries. He was a health nut other than all those fried items. And then let's see. The other gentleman that was interesting, a guy named Victor Figueroa, was executed in Iowa in 1963, and he requested a single olive with the pit still inside because his hope was that an olive tree would grow from his remains after he was buried. I don't know if that ultimately happened, but my question is, and the reason I bring up those issues is, what is your position on the prisoner getting their last meal? Do you think that's a ritual that should be honored by the state, or do you think it's something that you've had all these opportunities. We've given you all these appeals. You did do something pretty heinous to somebody else who's not here, and they didn't get a last meal when you killed them. So I don't know why you're getting ice cream and fried chicken. What do you think about that?
All I can think is that, like, personally, I don't think I would have much of an appetite.
Well, that's that one gentleman that ordered all those chicken and pizza and everything. He didn't eat any of it.
Like, I don't know, your governor signs your death warrant, you've got 30 days to live, and then it's like the night before the execution, you're supposed to have this great meal. It's like, I think I just would be just throwing up.
Yeah, I
Um,
think that'd be somewhat of a commentary on the particular type of person at issue. If you're about to walk down the hall, dead man walking, and yet you can sit down and eat 2 chicken fried chicken, some pizza, and some ice cream.
but, I'm for, if they're offering it, they're not getting much there on death row, so I wouldn't wanna see the final meal option being taken away from these guys.
Well, unfortunately, the gentleman that ordered all that food and neglected to eat it, after he did that in 2011, essentially they curtailed the final meal request issue. So he kind of ruined it for everybody else. So had he still been on death row, he would have had some upset neighbors about, why'd you ruin it for everybody? Yeah.
Just craziness.
Yeah, that's for sure. And the last question we'll ask about this, I'm going to talk to you about a few other things that you're involved with. But how do you? These cases are obviously very serious cases. And what I was just talking about is making a little bit light of the situation. Very morbid, very serious, very important role that you played in this process. But how do these cases, especially the hard ones, how does that linger with you after the fact? After these guys, you've given it your all. You've tried to make sure that the system was providing every due process that they're entitled to under the law. And sometimes you come up short because generally when you're walking into these cases, the deck's stacked against you from the start. How does that sit with you after the fact?
Well, I told you about the Paul Hildman case, and that goes way back. That goes back to 2002, and my guts hitting the floor. I think when the decision came out in 2004, it's real. It's difficult work, and when you think you're gonna win a case and you lose a case like that, that. It's really devastating. And like I said, I had successes, maybe one out of every 4 years or something. And I think that's why the public defender's office was maybe a little easier to work for than CCRCs, because you're getting a lot more opportunities to get big wins. So if you're at the public defender's office, so you might have a motion to suppress that you win, or a motion to dismiss, or you get the not guilty verdict. And so you're getting a lot of wins, and you're feeling good about what you're doing. But you're getting so many in post conviction, you're getting so many no's, you're getting so many denials. And so it's really tough to deal with that. And it's like, how did I deal with it after 20 years of doing it? I was like, I can't do this anymore. I got to call a timeout, or a long timeout. And I took 3.5 years off, and I was just kind of playing tennis and playing golf and playing poker and traveling and just trying to enjoy everything that life had to offer. But I mean, it's very difficult. And to think about, I remember it was November 1st of 2021. I remember I received a denial of one of my motions. And that's when I made the decision of like, I'm out. I can't do this anymore. So it was with the Paul Hildwin case, I lost that case, but I was kind of younger and I was not so jaded. And I'm like, we're going to fight. We're going to fight. This is total injustice. And let's move. Let's move. Let's appeal. Let's go to the next court and everything. But it was November 1st, 2021, when I received a denial of something which on the face of the record, it just looked like this is a unconstitutional death sentence and this guy's got to get relief. And this came down to a bunch of cases. It was Hurst versus Florida. And so in October of 2015, I went to view this oral argument at the United States Supreme Court. It was Hurst versus Florida. And the issue on the table was, is Florida's death penalty system constitutional or not? And they ruled, sure enough, they ruled January 12th of 2016 that Florida's death penalty system was in fact unconstitutional. And so a lot of changes were made, and we kind of go back to some of the old ways. But for a ways there, we had the requirement of unanimous death sentences. We don't have those anymore in the state of Florida. So, and it was strange what they did in this case following Hurst. They only gave relief to about half the people on death row. So it's like, okay, Florida's unconstitutional. What are we going to do? So the Florida Supreme Court basically, they say, split the baby. And there were about 500 people in Florida's death row. And they gave relief. They vacated the death sentences for like 250 of them. And then they remained intact on the other 250. And so that was a good start. At the time, I think I had a caseload of about 16, and we received vacated death sentences on 8 of the 16. So about half my clients got their death sentence vacated, and that felt really, really good. But what felt really, really bad is when this client, his name is Mark Poole, and he got relief based on the Hurst case, and they vacated his death sentence because they said state of Florida's death penalty system is unconstitutional. They vacated his death sentence. Well, then they took it away. Then they flipped the death sentence back on him. There was kind of a changing of the composition of the Florida Supreme Court. The quote unquote liberal wing retired due to age, restrictions. So Justices Lewis and Pariente and Quince had to retire, and then 3 new justices came in. And so where Mark Poole had received relief and got his death sentence vacated because certainly, his death sentence was made unconstitutionally, the changing of the guard, they reversed that precedent. So that was a disturbing case, very disturbing case to me, because I felt like I was completely robbed, and I felt like Mark Poole was robbed. And like I said, it's like, so they vacated his death sentence, and then like a couple of years later, they judicially imposed the death sentence back on him, and he's still fighting. And it's very tough to take all these losses and take all these no's and continue to hold your head up and continuing to fight. I just feel like you're kind of like banging your head against the wall, and sometimes like screaming into the void and making these arguments, and no one's hearing them. And so it's tough, man. It's tough business. And I tried to go back after 3.5 years, but I was just like, I'm going back to retirement, So I'm happily re-retired now,
Yeah, that's awesome. And doing this for 20 years, how many of the people that you represented actually got to walk out of the jail and go free?
Paul Hildwin went free. There was another one, Crosley Green, who was about to go free, but I think the 11th Circuit Court of Appeal took away his relief. So it looked like he was going to walk off of death row, but he's still there. And that was a case out of Brevard County, and there was a big 48 hours program on the Crosley Green case. but not my personal client. I can't remember his name. This was an interesting case. It went up to the Florida Supreme Court, and the Florida Supreme Court said, there's no evidence against this guy, zero evidence. And he walked off a death row. I wish he would have been my client. I mean, I wish that would have been my appeal, but it's just amazing to me that a guy can be convicted and sentenced to death and then go all the way through that process and have the Florida Supreme Court have to reverse that sentence to say there's no evidence against this guy. So I had Paul Hilden walk off death row, but I've had Virginia Larzalier was one of my first cases, and she got her death sentence. We got her death sentence vacated. At the circuit level, the judge vacated her death sentence, and then that decision was affirmed at the Florida Supreme Court. Was really hoping to get her a whole new guilt phase trial, but we were only able to get her a new penalty phase trial, and then ended up not seeking the death penalty again. So now she's serving a life sentence, but she's trying to get out on parole. Eric Simmons was a case out of Lake County. And again, this was one that I thought we should have won guilt phase relief. We should have gotten a whole new guilt phase trial. But the Florida Supreme Court on appeal just vacated the death sentence. And so that was a tough one because I thought I still have real doubts about his guilt, Eric Simmons. And I don't know if he's still fighting through the federal courts to try to get some justice. But so I guess the short answer is one. But in a way, to get a death sentence vacated is just as much, if not maybe more significant. Well, can be more significant, but you're talking about very high stakes of the deprivation of life without due process of law. So I'm happy that I was able to save some lives in my 20-year career, and there's been a few significant victories.
Well, that's awesome. And you mentioned in your spare time, you enjoy playing tennis, you enjoy playing poker. I know you enjoy racing cars, things of that nature. So to close out, Dave, I'm just going to ask you a couple of questions. They're yes or no questions, and you can expound on them if you feel like you need to. By all means, please do. So you'll understand the questions when I ask them. They're pretty basic, and you're a smart guy. I went to NYU. That's the only place you applied. So I know you're a smart guy. Federer, Nadal, or Djokovic?
Federer.
Why Federer?
Well, I just watched Nadal. That was a great program. But I mean, he's obviously the king of clay. But all around, all surfaces, the U.S. Open titles, and if you look at all the titles that Roger Federer had, really good attitude too. Roger Federer is a great ambassador for the sport. Djokovic is good too, but got to side with Federer on that question.
Yeah, and Federer, he looks like a tennis champion. If I had to conjure up in my mind's eye somebody who looks like a tennis player, Roger Federer checks a lot of those boxes. And he was obviously a champion for so long, as was Nadal, as was Djokovic, and they're all fabulous players in their own regard. So it's a little bit of a trap question, but everybody's got their favorite, and you're going with Federer, and that's completely fine. Stock car, Indy car, or Formula One?
Formula One.
All right. Do you prefer the Daytona 500 or the Indianapolis 500?
Daytona 500. Like my first foray into seeing a live race was at the Michigan International Speedway. So I used to be a big NASCAR fan. So it was back maybe in 1995 or 1996. So I remember going up to the fence there at the Michigan International Speedway and those cars coming down the straightaway, all doing like 200 miles, just literally blown away by the speed. And so, that was kind of like my first love of auto racing was NASCAR, the stock racing. So I got to go with the Daytona 500 over the Indianapolis 500. Although our local race in our own backyard, the St. Pete Grand Prix, I've been to that a couple times, and that's just an incredible race. That's an incredible setup that they have out there, and it's great to have that right here.
Texas Hold'em or Omaha?
I'd say Texas Hold'em. I mean, I was playing some of the Omaha high-low, but it's difficult to think of like, I'm trying to get the high hand and the low hand and too many cards, 4 cards. I've read maybe like 20 books on Texas Hold'em. I've been playing since 2004. I remember seeking refuge when Hurricane Charlie was rolling in, and I had a car that was really low to the ground. And I'm like, I got to get to the Hard Rock. We got to get it up in the garage. I don't want to have this car wash away. So I've been playing 20 plus years, and I stick pretty consistently to Texas Hold'em. But Omaha is pretty cool. I played one tournament at the Hard Rock, and it was like my first Omaha tournament. And I ended up going to the final table and winning a little bit of money. So that was cool. And speaking of Hold'em, I will be headed on July 2nd, going back out to the World Series of Poker. I'm going to try my hand at the main event. I've never actually played in the main event, and that's kind of a bucket list item. So, yeah, looking forward to that.
The moon landing, yes or no?
Got to go with yes.
All right. Coke or Pepsi?
Coke.
Aliens.
Aliens. Yeah, I think they're out there. I think X-Files. Agent Mulder, he said, believe. I think I believe. I will tell you, aliens, funny story. I'll try to be quick with it. I had a kid. He was in a juvenile facility, incarcerated. And one day he's not there and they charged him with escape. And so it was like, well, what about alien abduction? I was kind of floating that defense out there. Can I go with an alien abduction? How can the state say that he wasn't abducted by aliens?
Yeah, that's a good one. I'd like to see that motion drafted and filed, and then see the judge reading it and call you up to the bench and like, really?
C4 motion to dismiss.
If you could fly, time travel, or be invisible, which one would you pick and why?
I think time travel, yeah, I think it would be great to know who won the game, come back and you just be the king of the sports book. That would be so awesome.
Yeah, as a gambler, that would come in handy. What's your favorite sport?
Favorite sport? Definitely got to be tennis.
What about hobby?
Poker.
All right. Does ketchup belong on a hot dog?
Yes.
What is your favorite book?
Favorite book? Yeah, and I talked to you about this when, I heard your questions about the time travel. I really liked 11/22/64 by Stephen King, and that's a great time travel book where the character goes back and in time and tries to prevent the assassination of JFK. That's a really, really cool book, but I'm a big Stephen King fan, so The Stand is up there as one of my top favorite books as well.
Yeah. What about your favorite movie?
Favorite movie would be probably Casino with Robert De Niro and Joe Pesci and Sharon Stone.
It's a great movie. What about sequel?
Probably Terminator 2 Judgment Day.
What about favorite song?
Well, I still remember, I don't know if you remember when that radio station was at 98 Rock, all they did was play Stairway to Heaven. They played it like over and over. That's the only song they played for like a month or something. But yeah, that's might be my favorite song.
Yeah, that's funny. When I was in high school, there was a Tampa radio station called Wild 98.7. And I think a gimmick to launch the radio station or the channel or whatever they call those things, they played Wild Thing by Tone Loc, like on repeat over and over and over again. I think it was for 3 or 4 days straight. And they were saying that they pirated radio station. They were off the coast in some boat or whatever. It was just a big marketing scheme to launch what it later turned out to be just a rap station. But maybe they were doing the same thing over there with Stairway to Heaven. I don't know. If somebody wanted to learn more about the CCRC, is there a website that they go to?
I haven't visited that website in quite some time, and I don't remember the website ever being anything too kind of involved or informative or anything like that. But probably the Florida statutes would be the best place to go. There's a whole section in the Florida statutes about the appointment, the process of the CCRC, the funding of the CCRC, and their duties and responsibilities and everything. So I don't know. I could be wrong. Maybe they revamped their website or something like that, but I don't remember it ever being too informative. But the Florida statutes, that's the go-to to find out what it's all about.
All right. Well, Dave, it's been a pleasure having you on PodNumbra today. Thanks for spending the time, and I really appreciate you informing us about the process and everything that you did in the system.
Thank you very much for having me.
All right, man.